Brand new out of the U.S. Supreme Court this morning. The U.S. Supreme Court has just agreed to hear a case that deals with whether or not public officials can block critics on social media. So this has been something that's been sort of percolating for a while. Different public officials have tried to block people on Twitter, for example. The president of the United States, Donald Trump, of course, tried to block people on Twitter. A lot of people on the left were very unhappy about it. But then people on the left have also blocked people on Twitter, including, incidentally, Alexandria Ocasio-Cortez has been noted to occasionally block people on Twitter and stuff like that. And so the U.S. Supreme Court this morning has granted a review in cases that deal with this exact issue. Can public officials block critics on social media or not? All right, so let's learn a little bit more about this issue. The U.S. Supreme Court on Monday has agreed to hear a case dealing with the issue of whether the First Amendment bars government officials from blocking critics on Facebook and Twitter. The justices took up the appeal by two members of a school board from Southern California of a lower court ruling in favor of school parents who sued after being blocked from Facebook pages and Twitter accounts that were maintained by the officials. So this is a school board case, and the school board people blocked the parents from being able to comment on the Facebook page, and they sued. The lower court said, hey, you can't do that. You can't block them. And now we're going to the U.S. Supreme Court over the issue. The justices also took appeal from a Michigan man of the lower court ruling against him after he sued a city official who blocked him on Facebook following critical posts. So we have two different decisions. We have one from Southern California saying, hey, school officials, you can't block people. And one from Michigan saying, hey, city official, you can block people. So we have inconsistent decisions from two different places. And so the Supreme Court takes up both cases, and we're going to review it. At issue is whether public official social media activity can amount to governmental action that bound by the First Amendment. So is this governmental action, for starters? Is a social media account run by a politician a governmental action? The justices faced similar issues in 2021 involving legal disputes over Donald Trump's efforts to block Twitter. The justice was brought an end to that fight after Trump left office, deciding the case was moot. And then the lower court threw out its own ruling, incidentally. So the lower court decided, we're not so sure about that, and actually ruled against itself, which was pretty funny. The California case involves elected members of the Poway Unified School District. They blocked parents of 3 students at schools on Facebook and Twitter after the couple made hundreds of critical posts on issues such as race and handling of school finances. These parents sued in federal court claiming their free speech rights had been violated. The school board members each had public Facebook pages identifying them as governmental officials. The page was entitled T.J. Zane, Poway Unified School District Trustee, and included a picture of school district signage, which sounds like it's an official governmental thing as opposed to a personal thing. O'Connor Radcliffe also had a public Twitter profile. On that account and Facebook page, she identified herself as president of the Board of Education and a link to her official email address. A federal judge ruled in favor of the parents. The San Francisco-based Ninth Circuit agreed, finding the school board members had presented their social media accounts as channels of official communication with the board. The Michigan case involves a Port Huron resident who was blocked by a city manager after posting criticism relating to COVID-19. That individual sued in federal court, claiming their rights were violated. The account in question was a public Facebook page that identified the person as a public figure, included a picture of him wearing the city manager's pin, and frequently included information about city programs and policies. A federal judge ruled in favor of the public official's account in that case. The Cincinnati Sixth Circuit agreed, finding the public servant had not been acting in his official capacity when he blocked the pages. So you can see you have two very, very similar situations with two different decisions. You have school board officials who on their pages seem to be identifying themselves by their official capacity using official email addresses and so forth and so on. The Ninth Circuit says, okay, that is governmental action. And then in the Sixth Circuit, you have a very similar situation with a public city manager who identified himself in similarly public ways. But the Sixth Circuit goes the other way and says, no, this is not official action. So, is this official action, or how do you define official action in the social media context? And can public officials block the people? Two inconsistent decisions, both on review. Thus, we have this brand new CERT grant, which just happened this morning. That's how up to date we are here on Uncivil Law. Brand new CERT grant from the U.S. Supreme Court, where they grant certiorari in two cases, a Ninth Circuit case and a Sixth Circuit case, which reached inconsistent decisions with each other. And the U.S. Supreme Court is now going to review the issue on whether or not social media accounts are governmental action, or I suppose when are they governmental action, if ever? And then, assuming they are governmental action, can one of the actions be to block accounts or block people on those accounts? Can you block people in that way? So that'll be interesting to see how the Supreme Court deals with that. The Supreme Court has previously allowed governmental actors to block particular means of communication. For example, people who are harassing on phone calls because they take up too many resources. Now, presumably, social media doesn't have that same problem, but there is at least some precedent for the idea that public officials might be able to block certain people from certain channels of communication. So we'll see how all that reads on the social media age. And at least for the moment, that brings us to the end of the discussion of this story.